Okay, so this is our week three. Oops, sorry, everybody. This is week three. We're going to be talking about spousal support and property division. We have two guest speakers with us today. We have Anna Lang. She's a retired lawyer. We also have Nancy Chen, a lawyer and mediator. So, here. A quick territorial acknowledgement. We've gone through this before, but we just want to make sure we have our acknowledgements. About Amici Curie, again, we're a nonprofit organization, began in 2011 with a legal forms workshop. We now currently have about 45% of our clients as family law. And this program that we're dealing with, our 11 weeks, is the first program of its kind. Okay, so our chair acknowledgements for the family law school would not be able to have any of this happen without these people. So we just want to make sure we acknowledge them and all their hard work that they put into this program. A reminder to everybody that AC does not provide any kind of legal advice. This is a legal information session only. A quick reminder about the difference between legal advice and legal information. Legal advice is answering questions or providing information that is specific to somebody's case. Legal information is answering a question or providing information that is more general. So we are only going to focus on legal information tonight. Any questions that are going to be asked, please make sure that they are general only and provide for legal information, not legal advice. So everybody, like I said at the beginning, just make sure that you have your screen's off the entire time. The session will be recorded. So for privacy, just keep everything, you're muted and your video off. We will send everybody recordings about each session. Just give us a little bit of time as it takes a few days for us to get it all started. If you haven't already, make sure you send in your participation agreements, and any information is just into the chat box. A reminder to make sure you respect all of our speakers, staff, and volunteers. If you have questions, please make sure that there's no any harassing language or behavior. We do reserve the right to kick anybody out if there is any kind of harassing or rude behavior. Okay, so about our first speaker, this is Anna Lang. She was a lawyer for 34 years, and her main area was family law during those 34 years. Our second speaker tonight will be Nancy Chen. She is a lawyer and mediator. She was called to the bar in 2012, and she works exclusively in the area of family law. She's been a mediator since 2021, and she speaks English and Mandarin Chinese. Our objectives for this week, we're going to understand who can claim spousal support and the factors affecting the amount of spousal support that can be claimed, identify the types of family property and family debt, and understand what qualifies as excluded property. And at the end of the session, we'll have a quick 15-minute question and answer session. Okay, so I'm just going to invite Anna to turn on her screen so we can start talking about spousal support. Perfect. Hi, Anna.
Hi. Yes, I told Rachel that it's been 6 months since I had to be on Zoom and I've forgotten how to do everything. So bear with me.
No worries. So just let me know if you need me to change to the slides, okay?
Will do. Thank you.
you.
Thank you, everyone, for attending this evening. I'm here to talk about spousal support, which you will sometimes hear referred to on shows and in media as maintenance or alimony. Alimony being particularly a term you'll hear on US shows, but in BC, we typically use the language spousal support, and that is describes a payment from one spouse to another, typically paid on a monthly basis. And the goal of my presentation today is to tell you when a spouse has to pay spousal support to the other spouse, how the amount of support is decided, how the length of time that it's paid for is decided, and the factors that affect the payment of spousal support. There will be some terms that I use throughout the presentation. The recipient is the spouse who gets the support. The payor is the one who pays the support. And when I referred to the DA, that's the Divorce Act, and the FLA is the Family Law Act. So I will take the next slide, please, Rachel. Now, the legal basis for spousal support. And the reason I'm talking about the legal basis is because if you're making an application to court related to support, you'll be asked to describe in the court papers what the legal basis is for your claim. So in the case of the Divorce Act, I've set out the way you should describe the act in your notice of application. And the Divorce Act is federal law enacted by the Government of Canada, so it applies all across the country. It applies to legally married spouses only, and it applies in BC Supreme Court. The Family Law Act is a BC law enacted by the provincial government. And in addition to applying to married spouses, it also applies to spouses in a marriage-like relationship. And if the spouses don't have children, that relationship has to have lasted for at least 2 years before they separated. But if they have a child together, it can be a marriage-like relationship of any length. You will commonly hear people being referred to as common law spouses, but the proper term in BC is spouses in a marriage-like relationship. And the Family Law Act can be referred to in the BC Supreme Court and the provincial court. And there isn't much difference between these two laws. And so the Divorce Act does not apply to you if you are simply living together. Now, one quick note I want to make about provincial court and Supreme Court, and one of the questions would be, why would you go to BC Provincial Court instead of Supreme Court? Well, if you don't have any property to divide, then you can have your support issues dealt with in the provincial court. Or if you have, also issues to deal with just with your children, you can have that dealt with in the provincial court, and you may find that a more user-friendly place to go than the Supreme Court. So the purpose of spousal support, it's the same in both the Divorce Act and in the FLA. The purpose is described in the same way, and it is essentially to deal with the financial consequences of a relationship. And in more detail, there might be economic advantage to a spouse resulting from the relationship. There might be economic disadvantage to a spouse resulting from the relationship, or resulting from the breakdown of the relationship. Another purpose of the spousal support provisions of the two acts is to make sure that the spouses share the financial consequences arising from the care of their child, and to make sure that if a spouse suffers from economic hardship because of the breakdown of the relationship, they get spousal support to deal with that. And finally, to promote a spouse's economic self-sufficiency within a reasonable time, if it's practical to do so. Now, turning to each of these factors individually, what is economic disadvantage to a spouse arising from the relationship? Well, maybe a spouse was out of the workforce for several years to look after the children. In that case, Rachel, if you can go back to that previous slide, thank you. in that case, they may be at an economic disadvantage because now they don't have the skills they used to have. They lost seniority that they would have had in, the occupation they had before. And so that's a disadvantage. An economic advantage, sometimes a spouse might receive support, not because they suffered disadvantage themselves, but because their efforts during the relationship resulted in an ongoing economic advantage to the other spouse. So, for example, Mr. Jones puts Ms. Jones through university. And then after a few years at her job, Ms. Jones, takes some extra courses that require her to be away from home for a bit of time. And she can do that because Mr. Jones is at home looking after the home and the children. And because Ms. Jones has that extra education, she's able to become the CEO of the company that she works at. So she has enjoyed an economic advantage because of the contributions of Mr. Jones, and Mr. Jones should get support to compensate him for that. Now, the promoting a spouse's economic self-sufficiency, that is one of the purposes of spousal support, but it is often not the most important one. There is an expectation that a spouse will try to get back on their feet, and so maybe support is paid to allow. Oh, there's a good question there from Julia. I will answer that later, so I will flag that on the chat. A spouse's economic self-sufficiency, may require that they go back to school and upgrade their skills. And so maybe they get support to enable them to do that. Okay, now we can go to the next slide. There are 3 kinds of spousal support, or 3 reasons that a judge might award spousal support. The first is compensatory support. And so, as I previously mentioned, if someone has given up opportunities due to the relationship, left their job to take primary responsibility for the home and the children, and now has suffered an economic loss, they will be entitled to compensatory support. And again, as I just discussed, compensatory support can also be ordered to compensate a recipient for the benefits the payor gained because of the recipient's role in the relationship. Non-compensatory support is support that allows a recipient to continue to meet their living expenses if they can't afford to do so on their own resources. And so it's not so much that you gave up anything in particular, but maybe you were always the lower earning spouse, and during your relationship, it was your spouse's, the payor's income that allowed the two of you to enjoy the lifestyle that you enjoyed during the relationship. And so in that case, support may be ordered to allow the recipient to continue to enjoy that relationship lifestyle. The least common basis for ordering support is contractual, and that is support that's been agreed to by the spouses in a contract. So there might be a prenup, or there might be a separation agreement that provides for support. The vast majority of support cases that we see are either based on compensatory or non-compensatory support. Now, the next thing I'm going to say is very important. Entitlement. You cannot get support unless you can demonstrate that you have entitlement to it. So you have to be able to prove that you are entitled to support on a compensatory basis or on a non-compensatory basis or on a contractual basis. But you don't get support just because you were in the relationship. You don't get support just because the payor makes more money than the recipient, unless you can show one of those three bases for support that I just discussed. So for example, if you get a young couple gets married in their 20s, they both continue to work and they split up after 2 years, it is very unlikely that there will be entitlement to support for either of them, even if one of them makes more money than the other. It is possible to be entitled to support on more than one ground. I would often see cases where a spouse had entitlement on both compensatory and non-compensatory grounds. And so it may sometimes be the case that even if you are no longer entitled to support on one of the grounds, maybe you now earn enough money to meet your living expenses on a daily basis, and so you're not entitled to non-compensatory support. But maybe you are still suffering economic disadvantage because of the relationship. You lost your seniority, and when you went back to work, you lost on all the pension entitlement that you otherwise would have earned during the years of the relationship. In that case, you may still be entitled to compensatory support. So let's assume that you have established entitlement. The next thing you have to have in mind is the time limits to bring your claim for spousal support. So if you have got the entitlement, but you don't bring your claim within the time limits, and we're at the next slide now, please. If you don't bring your claim within the time limits, then you can't get support, even if you've got entitlement. Now, when we talk about time limits, it does matter which law you're relying on. So in the DA, there is no time limit. But, if you wait an extremely long time, if you wait 5 years or 10 years to bring your claim, a judge may look at you and go, well, maybe you didn't actually need support because you waited for so long. So it's always better to act in a timely manner when you're making these claims. Also, important to keep in mind that a spouse includes a former spouse. So even if the spouses are divorced, so one spouse files a claim saying, I want a divorce, and that's all they ask for, and they get the divorce. That does not prevent the other spouse from bringing a claim for spousal support after that. Now, it's a different story under the Family Law Act. And the Family Law Act, it's a bit different depending on whether you are married or unmarried. So if you are in a marriage-like relationship, the time limit to bring your claim for support is 2 years from the date of separation. And this can get a bit sticky because it's not always clear when a separation occurred. Sometimes the spouses might be trying to work things out. Maybe sometimes someone leaves and then they come back and they give it a go for another couple of months, and then things don't ultimately work out. And so sometimes you'll get the spouses fighting about what's the date of separation because of this 2-year time limit. If you're married, it's a little more straightforward because the time limit, and again, so if you're bringing your claim for support only under the FLA and not under the Divorce Act, then again, you've got a 2-year time limit, and that's 2 years from the date of your divorce or from the date of the annulment of the marriage. And just to be clear, annulment is very rare. And so usually we talk about the date of divorce. And that's very clear. You've got a piece of paper that tells you when you were divorced, and so it's clear when the 2 years starts to run. Now, another wrinkle under the FLA is that although there's this 2-year time limit, the time limit is suspended if the spouses are taking part in family dispute resolution. So if they're mediating or they are trying to deal with their issues through a family justice counselor, or if they're dealing with a parenting coordinator about their children, that apparently is enough to suspend the time limits for everything, and that includes bringing your claim for support. So, and again, that can be a bit tricky because the spouses might say, well, I thought we were still in the mediation process. And so again, people can get into a fight over when the actual time limits were. Now, the next question that arises is how to decide the amount of support. It's easier than it used to be. So for the first part of my career, it was all about the budgets, and each spouse would prepare their estimate of what their income was and what their expenses were, and then the judge decided how much the payor had to pay based on the budgets. It was very inconsistent, and you could never give your client an accurate estimate of what they would have to pay. In 2008, the federal government released the Spousal Support Advisory Guidelines. And it's important to note that these are not law. They haven't been enacted into law by any legislature or government, and they're technically not mandatory, but in BC, they are used by our judges as if they were mandatory and if they were law. And the purpose of the guidelines was to provide a little more consistency to spousal support. And so I think it's fair to say that they probably have accomplished that goal. And as I said, the judges use the SAGs as if they were law. And our Court of Appeal has said if a judge makes an order for support outside of the SAGs and doesn't give a good reason for it, that might be an error that the Court of Appeal can overturn. And so the SAGs basically provide a range of monthly support amounts. There's the low end, the mid-range, and the high end. And these are based on the differences between the spouses' incomes. The SAGs also refer to ceilings and floors. So if a payor has an income of less than $20,000, they won't be required to pay support. If the payor's income, on the other hand, is over $350,000, then the judge has discretion as to whether to order support paid on the income over $350,000. And so when the SAGs first came in BC, a lot of lawyers tried to say, okay, well, $350,000, that's, even if your income is $500,000, you only have to pay based on $350,000. And eventually our judges decided, no, there's no hard and fast rule about that. The court just has a discretion as to how much gets paid where the amount is the income is above $350,000. And typically what happens is that the court says, is the amount of support on the SAGs so excessive to the monthly needs of the recipient, and that's where the budgets come back into play. Um, uh, you know, is the amount so excessive that it would be unreasonable to make the payor pay? And I'll give you a really simple example here. Um, you know, about 15 years ago, the lead singer of Nickelback's split up from his girlfriend. And they had been together for a number of years. And his income the year before was $9 million because he was the lead singer of Nickelback. And so, under the guidelines, uh, he would theoretically have to pay her $90,000 a month in spousal support. And of course, he said, that is way too much. Our lifestyle was not based on $90,000 a month. And she came back and said, yeah, it was $50,000 a month. And so that is what the judge ended up ordering on an interim basis. Yeah, I know that those are crazy numbers, but that's what happens when you're a rock star. Now, um, so that is me anticipating this next slide, which is awarding support outside of the range. And so when does the court order support at the low end? And I will tell you that the default, the judges, lawyers, they all like to default to the mid-range because that's nice and easy. But sometimes you will get someone arguing that support should be paid at the low end. And maybe that is justified if there's a lot of property to divide. And that property will allow um, the recipient to generate income, or maybe the agreement is that the recipient will get more of the property. So again, forgive me if I default to she, but in the majority of my cases, over 34 years, the recipient was always a she. So the recipient might get more of the property, again, in order to allow them to um, generate some income on that. A lower amount of support might also be ordered if it would encourage the recipient to make some effort to go back to work if they're not making a reasonable effort. The high end of support might be justified if the recipient has a very strong compensatory claim. And you may get cases where there's a lot of property and it's divided equally, but then support is also awarded at the high end to recognize the very strong compensatory claim of the recipient. You also might get support at the high end if there isn't a lot of property to divide, but the payor has a good income. And so then the payor's income being ordered at something other than the ranges. If there's an extremely high income, that's the Nickelback singer example that I just gave you, that, if he had to pay based on the guidelines, it would go beyond the purpose of support. It would be effectively transferring some of his wealth to her. And so that's why the judge ordered less than the guidelines amount. Now, we've got these guidelines, and you'll notice when you look at the guidelines, they don't actually have any figures in them. So how do you know how much support has to be paid? And that's where the support calculators come into play. And you will often hear people referring to DivorceMate. That is certainly, in my experience, the most commonly used support calculator in the legal profession. And the issue with DivorceMate is that it costs money. and it is not cheap. So one of the ways you can deal with that is by having access to some of the free online calculators, and the information is there as to where to find them on the internet. These are very basic calculators. If you've got a situation that's a bit outside the ordinary, you've got income that maybe isn't just T4 income, then the online calculator might not be useful for your situation. And so both of these online calculators provide options to upgrade the calculator to deal with some of those more complex situations. And the fee that they charge to upgrade is less than the fee for the commercial calculators. And I will say one thing to keep in mind, if you are going to court and you know that let's say the other party has a lawyer and they are producing these divorce mate calculations, first of all, be aware that you can't expect or you can't count on the judge having access to divorce mate and being able to run their own calculations. Not all judges have access to it. Not all judges know that they can get access to it. I know some judges who have made a point of getting access to divorce mate, but it's certainly not all of them. And so, if the calculation of spousal support, if that's a big issue, and you are able to maybe get the services of a lawyer who provides unbundled services, meaning that they don't need you to hire them for the whole case, but they will do pieces for you. It might be worth paying them for an hour of their time or their paralegal's time to run some calculations for you, or to double check the figures that you have from the online calculator. And so, it's useful for you to have something to give to the judge that, if you say that your ex's calculations are off, you want to have your calculations before the judge. Now, factors that affect spousal support, the most important factor affecting spousal support is the existence of children in the relationship. The existence of children affects both the length of time that support is paid and the amount that support is of support that gets paid. If there are no children, the length of time support is paid is directly tied to the length of the relationship. It's a half a year to 1 year for each year of the relationship. So if you've got a 10-year relationship, support might be paid for anywhere between 5 to 10 years. But if there are children, the length of time support is payable is linked to the age that the youngest child leaves school. Now, that doesn't mean that it will always definitely be paid until the youngest child graduates, but that's the starting point. And then you look at alterations to that. Maybe when the youngest child starts high school, the recipient is now in a position to go back to work full time, and is now able to become self-sufficient. But the payor is going to have to make that point, because the default is pay until the youngest child leaves school. The other way that children are a factor is that child support takes priority over spousal support. And so you sometimes have situations where the payor simply doesn't have enough money to pay spousal support or the full amount of spousal support. um, because child support takes up so much of their income. And so in that scenario, and so, the recipient may have entitlement, but the money just isn't there. And so in that case, the recipient might have to ask for more of the family property, or might have to ask the court to order that spousal support can be reconsidered once the child support ends. The next factor that affects spousal support is the length of the relationship and the age of the spouses. And so the longer the relationship, the greater the entitlement of the recipient to enjoy a lifestyle equal to that of the payor. Now, equal lifestyle does not mean equal income, but it does mean the standards of living should be equivalent. And so if, for example, the recipient's entitled to non-compensatory support, and they are meeting their expenses, but only because they've cut back. And they're living a lifestyle that's far reduced from what the relationship lifestyle was. And the payor, on the other hand, is enjoying the same lifestyle that they enjoyed during the relationship. He doesn't get to say that the recipient doesn't have entitlement because she's able to meet her daily needs, because her daily needs, she's only meeting them because she's cut back so much. She's got entitlement because she's entitled to have a payment from the payor that allows her to increase her lifestyle back to what it was during the relationship. Now, if the payor doesn't have enough income to support both of them at the relationship lifestyle, then they'll both have to cut back so that they enjoy equivalent reduced lifestyles. Oh, sorry, if we can just go back, Rachel, thank you. If a relationship is 20 years or more, where the combined length of the relationship and the age of the recipient equals 65 or more, then support is indefinite, meaning there is no fixed end date. And so that doesn't mean that support is always payable. It just means that there isn't a termination date. So the payor is still able to come back and say, for example, I retired and my income has gone down. Now, typically a payor will say my income has gone down and so I cannot keep paying support. But if the payor, even with retirement income, has greater income than the recipient, then what might happen is that the payor still has to pay support, but just in a reduced amount. Now, if you've got a shorter relationship and support is non-compensatory, then really the purpose of support is going to be to help the recipient transition back to the pre-relationship lifestyle. And so there will be a fixed termination date. Okay, so income of the recipient spouse. This affects spousal support because a recipient has a duty to contribute to their own support to the best of their ability. So even if a recipient is unskilled and has been out of the workforce for many years, they still have an obligation, even if that is to, earn what they can at a minimum wage job. Now, that doesn't mean that if they get the minimum wage job and they're working full time, that the payor doesn't have to pay support. Because remember, it's the difference in incomes that's our benchmark here. So, so while the recipient may have a duty to contribute to their own support, that may not be enough to permit them to be fully self-supporting. So if you were at home for 10 years, you can't say, I was home and I don't ever have to work again. No, you have to do what you can do. If you if you don't make any effort to contribute to your own support, then the judge will impute income. They will say to you, I think you're capable of, at a minimum, working at a minimum wage job full-time, and this is what you would earn, and so I will say that this is your income. Okay. Now I'm not sure, maybe factors that affect spousal support, tax. That's the slide we should be at. Okay. Monthly support, taxable to the recipient, a tax deduction for the payor. The SAGs assume income is taxable T4 income. And so if a spouse's income is non-taxable, let's say because they have First Nation status and are taxed on their income, that might change the SAG calculations. Or if the income is subject to a lower tax rate, like capital gains income, if you sell a rental property, or the SAG calculations might change if a spouse lives somewhere else where support isn't included in the recipient's income or deducted from the payor's income. So you might have a situation where after the relationship breaks down, one of the spouses leaves BC, and the tax regime there is different. And so that might have an impact on the support calculations. Now, very important for a recipient to remember that spousal support is taxable. And I often saw cases where the recipient hadn't set aside part of the monthly payment for tax, and then they got stuck with a big tax bill come April. Now, in order to get the deduction, the support has to either be documented in a written agreement between the spouses or set out in a court order. And it has to specifically refer to spousal support. So if the order or agreement says Ethan will pay Ashley $4,000 a month, but it should actually be $3,000 in child support and $1,000 in spousal support. If you just say it's $4,000 in support, CRA, the Canada Revenue Agency, will assume that it's all child support, and child support is non-deductible to the payor. So very important to document it properly. Okay, factors that don't affect spousal support. The fact that one spouse made all the money. I often had clients who would say, well, she didn't do anything during the relationship. I earned it all. That doesn't matter. That's not recognizing that the other spouse was making contributions of a different kind, looking after the kids, looking after the home. So that doesn't matter. Fault doesn't matter. The Divorce Act, Family Law Act, these are no fault regimes. So if the payor had an affair and left the relationship, that doesn't make them more liable to pay support. If the recipient had the affair and left the relationship, if the recipient can show entitlement, they still get support. If there is family support, so the recipient left the family home, went to live with their brother, and is living rent-free in the brother's basement suite, that doesn't reduce the entitlement to support if they've got a compensatory claim, or even if they've got a non-compensatory claim, because um, uh, you know, if the payor isn't living in their brother's basement suite and has a better lifestyle, the recipient shouldn't have to um, uh, lose out on support just because their family has chosen to support them. It's not their obligation to support the recipient. Now, types of support orders, interim support. So this is intended to bridge the gap until the final resolution of the case, either through trial or an agreement. And that is, that is where you'll file your notice of application to court asking for an interim order of support. On an interim application, the judge does not fully examine all the facts, will not comb through everything. The judge will do what is necessary on a rough and ready basis to make sure that both spouses are economically sound until trial. A final order is an order that's made after trial or after an agreement. It might be a fixed amount, subject to review or variation, which I'll talk about in a second, or it might be an amount that's regularly recalculated each year after the spouses get their tax returns. Now, I will say with an interim order, it is possible that when the court makes the interim order, the judge may not have all the facts in front of them. The judge may not, because the judge hasn't been able to do the in-depth analysis, there may be an overpayment or an underpayment. The expectation is that that will be dealt with when the final order is made, but I will say in practice that doesn't always happen. So if you think there is an underpayment or an overpayment, don't forget to deal with that when the final order is made. Then, now, I've been talking mainly about monthly support, which is called periodic support, but another kind of support is lump sum, and that's a one-time payment. And so maybe, I see this a lot. One spouse says, I'll give up part of my share of the family property as lump sum support because they don't want to have to deal with monthly payments. A judge is not likely to award lump sum support unless the payor agrees to it, or there's a history that the payor won't pay. And if there is that history, then a judge might say, well, it's going to be a hassle dealing with monthly support, so we'll do a lump sum. But that then leads to, a possibility of overpayment or underpayment. So, underpayment, what if the payor subsequently gets a big permanent increase in their salary? And for underpayment, what if the recipient dies prematurely or comes into a windfall and the payor's made a payment that's intended to cover the next 20 years? So, but sometimes lump sum is useful because the spouses just want to be done with each other, and that allows them the clean break. Now, reviews and variations. If spouses' circumstances are uncertain, the order or agreement might say that after a certain period of time, we will review the support. So an example of that might be your recipient has just finished retraining in a new career and don't know if that is going to be a successful career. And so the order might say, we'll have a review in 2 years to see if the recipient is still entitled to support and what their income is. or you might have a review because everyone knows the payor is going to retire in 5 years' time. On a review, you don't need to show that there's been any change in the circumstances as between the spouses. That is different from a variation, which is our next slide. With a variation, you have to show that there has been a significant, unforeseen, and ongoing change in circumstances. And if there has been that kind of change, then the order or agreement can be varied, which is just another way of saying changed, to reflect the new circumstances. So, for example, the payor loses their job and despite their best efforts can't get a job that pays anything close to their prior income or becomes disabled. Or the payor no longer has to pay child support. Although, the payor might say that's not an unforeseen change in circumstances. That is something that would have been foreseen. And so it should have been the subject of a review. And if there was no provision for a review, I don't have to keep paying. And so, those are the kinds of arguments that I've seen being made. Or, the recipient earns far more than anyone expected, has become very successful post-separation. Then that might be grounds for a variation. And then specifically, the FLA also allows variation if essentially there's non-disclosure, or some new evidence comes to light that wasn't available when the order or agreement was made. And here's a very simple example. 6 months after the settlement, the payor's employer announces that the company's been so successful, they're giving 20% pay raises to certain employees, including the payor, and that increase is retroactive 8 months. So now the payor didn't know that was coming, but if they had known, at the time the order or agreement was made, that they were going to be getting this 20% raise, it would have been taken into account in making the support order. Now, let's say, on the other hand, the payor did know that this 20% raise was coming and didn't tell anyone. In that case, again, you've got an order that's made on incorrect information, and so the recipient would be able to apply to vary the support order to take into account that 20% raise. And then here's the question that everyone asks: is repartnering a change of circumstances? You find out on social media that your ex is dating someone new, or maybe they've even moved in together. If support is compensatory, repartnering is not a change in circumstances, because the repartnering is only going to have an impact on the recipient's ability to meet their day-to-day expenses. The repartnering has nothing to do with the loss that the recipient suffered as a result of the role played in the relationship. On the other hand, if support is non-compensatory, i.e. designed to help the recipient meet their expenses, then maybe the repartnering will be a change of circumstances. But, the factors you'll have to look at, is the new relationship a permanent one? Like, if the recipient and the new partner have been living together for 2 years, yeah, you know what? That's permanent, and maybe we should be revisiting the support. But if it's a permanent relationship with someone who earns less, than the recipient, then maybe it doesn't have any impact on the support, because maybe the new partner's own income only helps the new partner support themselves. So it's not an automatic. And it's complicated, just like all of spousal support, which I'm sure you've gathered from what I've had to say. So that's been your really quick trip through spousal support. And I see there are lots of questions that I'll be happy to answer at the end.
Perfect. Thank you so much, Anna. We really appreciate your time. So we're just about 2 minutes before we have 6:30 here. So if anybody needs a quick minute, we're not going to take the full 5 minutes, but we're just going to start again at 6:30 and have Nancy Chen start her presentation on property division. So we're just going to give it a couple minutes. We'll be right back. Hey, welcome back, everybody. Hopefully you were able to grab a quick glass of water or anything, and now we can get started onto our next part for week 3. So this will be Nancy Chen who's going to start speaking about property division.
Thank you, Rachel, for guiding us through tonight, and thanks, Anna, for your presentation. So I'll get started on my presentation on division of property and debt. So what is property and debt division? When spouses separate and either party has property or debt, the law provides how property and debt should be divided. So with this, first slide, Part 5 of the Family Law Act sets out the law respecting property and debt division when spouses separate. And as Anna noted earlier, there's federal legislation, the Divorce Act, and provincial legislation, so in our case, the BC Family Law Act, that apply to spousal support. However, for property and debt division, only provincial legislation, the Family Law Act, applies. And this is because pursuant to the Canadian Constitution, only the provincial governments can make laws over property rights. You can take note that Part 6 of the Family Law Act sets out the law respecting pension division, but I unfortunately won't have time to get into that today. And then I just also want to note that a Family Law Act is not the entirety of law governing property and debt division. So when you read the act, you'll see there's interpretation of the act, and we'll have to look at common law. So I won't get into things like the laws of equity and too much into other statutes and laws today. However, if for those people who don't have a legal background, it's important to know that another source of law is the common law, or what some people describe as judge-made law, So this is a body of law based on previous court decisions. So the idea is that if a judge at trial, for example, interprets the legislation a certain way and makes a decision on an issue, then another judge dealing with a similar situation in the future should be making a similar decision. So when you hear lawyers, or when I'll later say things like, in most cases, the courts find that, or for courts in similar situations, they usually do this and that. I'm referring to the common law, or the body of law made by judges. So, and then also, unlike spousal support, where both the provincial court and Supreme Court can deal with spousal support, the Supreme Court of Supreme Court of British Columbia has jurisdiction over property and debt division. The provincial court cannot divide property and debt, so don't start an action in the provincial court if you need to start a claim for property or debt division. So next slide is, so who is a spouse? One of the first considerations when you separate from a partner and want to divide property is whether you are a spouse pursuant to the Family Law Act. For the purposes of division of property and debt, Section 3 of the Family Law Act defines spouse as a person who is married to another person or has lived with another person in a marriage-like relationship for at least 2 years. As an aside, though, I want to mention that the definition of spouse is expanded when dealing with spousal support. So a person is a spouse for spousal support purposes if they've lived together for less than 2 years but have a child together. Whereas with property and debt division, you can see the definition there. You have to have been together in a marriage-like relationship for at least 2 years if you're not married. So back to property division considerations. It's obviously quite clear that you're a spouse if you're legally married to someone, but non-married relationships might not be as clear. So there are situations where people argue in court about whether the relationship was marriage-like or for under or over 2 years. So for property division, it's important to know or consider what constitutes marriage-like if you're in a common law situation. So generally, the courts have considered subjective factors such as the parties' intentions and expectations. So this would be whether the parties intended that the relationship would be a committed, lengthy relationship with usually an indeterminate duration. So that's the intention, expectation of the parties. And then there's the objective factors, the objective evidence a court would look at, which would be their behavior, including were they sharing a residence, are there sexual and personal interactions, financial arrangements, or is there interdependence in their finances? Are they spending time with each other's families, things like that. So the courts would would typically look at how the objective evidence lines up with the subjective intentions, and the assessment of the relationship is contextual and requires consideration of both subjective and objective evidence. A lot of people assume that they're only in a marriage-like relationship and they're living together. And that's usually the case. If you're living together, you're in a marriage-like relationship. However, there's been rare cases where the courts have decided that two individuals were in a marriage-like relationship despite living in, for example, separate cities and countries. So it is quite a case-by-case consideration. But generally, if two people are sharing one residence, financially interdependent, spending time together regularly, and show commitment to the relationship, they would be considered to be in a marriage-like relationship. And another important, I guess, issue to remember from Anna's presentation is there is a time limit to start a claim for property and debt division. So the time limit is the same as the spousal support limits that Anna was describing. So for common law couples, it's 2 years from the date of separation, and for married spouses, it's 2 years from the date of divorce. And Anna also detailed information about time limits being suspended during dispute resolution. So remember that these time limits also apply to property and debt division. So next slide. Thank you. So if you're a spouse and therefore Part 5 of the Family Law Act applies to you, then how is property and debt divided? So Section 81 is a key section to look at. So it states, subject to an agreement or order that provides otherwise, and except as set out in the pension division part, spouses are both entitled to family property and responsible for family debt, regardless of their respective use or contribution. And B, on separation, each spouse has a right to an undivided half interest in all family property as tenants in common and is equally responsible for family debt. So when we consider how property and debt should be divided, Section 81 is giving us a starting point of assuming that there will be equal division of family property and family debt. However, that is a presumption, and but there are also exceptions that I will discuss later on. There are some key terms that must be defined to understand how property and debt will likely be divided. So an important term you will see repeatedly in Part 5 of the Family Law Act is a reference to the date of separation. So as you see here at subsection 81B, it says at separation, so meaning the separation date is a point in time that creates a spouse's right to an interest in family property and equal responsibility for family debt. So a lot of my new clients who maybe don't have a lot of background on family law often ask me, when are they legally separated, or how do they obtain a legal separation? I think in some other countries they have such a thing, and they expect that there's some sort of document that they sign or they obtain in court that that declares that they've separated. So in BC, there's no such thing. You can't file or do anything that in court that says you are officially separated. But generally, separation occurs the day one spouse declares the relationship is over, and there's no intention to reconcile, and then one or both spouses behaves in a way that corresponds with that. So typically, separation is a physical separation coupled with one spouse's intention to live apart. Um, so, as all things you'll keep hearing, there are some exceptions. Although there are situations where one party declares they want to end the relationship, but then the spouses remain in the same home, but then they live in separate lives, and that is still considered a separation, even though they're living still in the same home, and maybe one person moves out a few months later. And you'll note that it's also, you don't require two people to agree to separate. One person can initiate the separation. And then, so Section 81B states that the right to an undivided half interest is family property and family debt, is in family property and family debt. So probably one of the first questions is then what is family property? So in terms of, are we on slide 4? Family property, Rachel? There, thank you. So Section 84(1) states, subject to Section 85, excluded property, family property is all real property and personal property as follows. A, on the date the spouses separate, property that is owned by at least one spouse or the beneficial interest of at least one spouse in property. Know that this means the property only needs to be owned by one spouse to be family property. I often have people asking me whether they get to keep all the property registered in their sole name, or some people are very concerned about all the assets being in their spouse's name. So the answer is it doesn't matter whose name it's in. If it's in your name, your spouse's name, or joint names, it's all assumed to be a family property. And then B, after separation, property, so this is continuation of what is family property. So B, after separation, property acquired by at least one spouse, if the property is derived from property referred to the paragraph above, or from the disposition of either the beneficial interest or the property mentioned above. or beneficial interest acquired by at least one spouse in property if beneficial interest is derived from property owned by at least one spouse. So you can read the rest of that. So in terms of so moving on to subsection 84.2. So it says, without limiting subsection 1, family property includes the following. A share or interest, a share or an interest in a corporation, an interest in a partnership, an association, organization, a business, or venture. C, property owned by a spouse, as a refund, including an income tax refund. So income tax refunds from taxes remitted before separation are considered family property, even if the refund is received after the parties have already separated. Next, we have property owing to a spouse in return for the provision of good or service. D, money of a spouse in an account with a financial institution, so savings accounts, checking accounts. E, a spouse's entitlement under an annuity, a pension plan, a retirement savings plan, so like RSPs, an income plan. Property, so F, property other than property to which subsection 3 applies, that a spouse disposes of after the relationship between the spouses began, but over which the spouse retains authority to require its return or direct its use or further disposition in any way. So the spouse still has control over that money, even if it's been transferred or disposed. And then G, the amount by which the value of excluded property has increased since the later of the date. The later of the date, first, the relationship between the spouses began, or second, the excluded property was acquired. So this often is what people are most interested or concerned about, is they brought property into a relationship. Some people think, well, that was my property that I brought in. I shouldn't have to share any of it, but the increase in value of that property is family property. And so far, this is the first mention of the term excluded property, and this is a key definition I'll discuss later on. But make note that here that when there is excluded property, the increase in value of excluded property during a relationship becomes family property. This means the value of the excluded property at the time the relationship started is an important value to retain. That's why it's a good idea to retain, bank statements, proof of value of your assets at the time you start a relationship. Most people don't think of that when you're starting, or you're just moving in with someone. But I have found in my practice, it comes in handy because, as probably many of you know, most banks don't keep records past 7 years. So it's a good idea to keep some of those types of documents at the beginning of a relationship. So the next important term to look at is what is then excluded property. We've talked about what's family property, then what would be excluded from property and debt division. So this is set out in Section 85 of the Family Law Act. So it states the following is excluded from family property. So A, property acquired by a spouse before the relationship between the spouses began. Inheritances of a spouse, gifts to a spouse from a third party, so gifts, for example, from family members to them. C, settlement or award of damages to a spouse for compensation for injury or loss, unless the settlement or award represents compensation for loss to both spouses or lost income of a spouse. So that could be, for example, ICBC personal injury payments, or at least the portion of it that is not related to the lost income. D, money paid or payable under an insurance policy other than a policy respecting property, except any portion of that represents compensation for, again, loss to both spouses or lost income of a spouse. Then D, property referred to in any of the paragraphs A to D that is held in trust for the benefit of the spouse. So it's not legally registered in the spouse's name, but it's held for their benefit. F, a spouse's beneficial interest in property held in discretionary trusts to which the spouse did not contribute, and 2, that is settled by a person other than a spouse. And then G, property derived from property or the disposition of property referred to in any of the paragraphs above. So I won't get too much into what is a trust and mentioned in F, what is a discretionary trust for our purposes today. But trust is a legal entity created where a party gives another party, usually the trustee, the right to hold title to and manage assets for the benefit of a third party, so the beneficiary. And so maybe if some people have more questions about that, we could maybe, if we have enough time, get into that later. But for now, I'll move on. Okay, so still on excluded property, section 85(2) states, so a spouse claiming that property is excluded is responsible for demonstrating that the property is excluded property. So again, as I mentioned earlier, it's helpful if you keep documents showing what property and what the value was at the beginning of a relationship, because if you're claiming that you have excluded property, you are the one that has to demonstrate that it is excluded. So if you don't have any evidence, it's going to be difficult to prove that. And then 85 subsection 85(3) states if property is excluded from family property under section 1, the exclusion applies despite any transfer of legal or beneficial ownership of the property from a spouse to the other spouse. So this subsection actually was only added and officially became law on May 12th of this year. So if you have a property division claim that was already filed prior to that date, then the previous law applies. But if you haven't filed your claim, or you filed your claim after May 12th of this year, then this new amended section 85(3) applies. So I want to give a bit of background on this one because it's quite a big deal for us lawyers and probably you guys as well. The new subsection 3 is a clarification that many family lawyers and probably judges have hoped for. So prior to this amendment, there was a lot of litigation over what happens if one spouse transfers their excluded property to the other spouse, or if one spouse puts their excluded property into joint names with the other spouse. There were many cases where the courts found that the owning spouse lost their exclusion when they put their excluded property into joint names. So the transfer or putting it into the joint names was seen as like a 50% gift to the other spouse. However, then there were also some other cases where exclusion was not lost. So it was dependent on the facts. There was, I would say, a dire need for some clarity. So this issue in the law was uncertain. It resulted in a lot of people going to trial over this issue. So this new subsection 3 takes a more definitive stance and clarifies that a party does not lose their exclusion if they transfer the ownership of excluded property to the other spouse. We can trace back, looking at that joint property, we would trace back, oh, how much of this property was from excluded property. So as I said, this was a welcome change for some people. And I think especially in a city like Vancouver, where many people can only afford to buy a home with maybe gifts from family, this amendment clarifies that a gift or inheritance from one party's parents, for example, for the down payment, that spouse is, even if they put that property in joint names, that spouse is not going to lose the exclusion. So the next slide, 45, page 45. So on to dividing excluded property. So now that we have an idea of what is excluded property and know generally that the presumption is that excluded property is not to be divided when spouses separate, there are some very limited situations where excluded property can be divided. So section 96 states that excluded property can be divided if there is family property or family debt located outside of British Columbia that cannot be practically divided. So an example of this would be if party A is a registered owner of real property in China, for example. The parties also own a house in BC, partially purchased with party A's excluded property. If there's sufficient evidence that party B will not be able to seek division of the property in China, the court may divide excluded property located in BC as a way of dividing family property located outside of its jurisdiction. And then the other part of Section 96 states, or excluded property can be divided if it would be significantly unfair not to divide excluded property, considering first the duration of the party's relationship and to a spouse's direct contribution to the preservation, maintenance, improvement, operation, or management of excluded property. So I'll get into this a bit more, but courts have stated that significant unfairness needs to be compelling and meaningful. So such that the consequences of not doing so would be so weighty as to produce an unjust or unreasonable result. So it is a high bar to meet, and it's not common. And so the next topic I want to address, now that we've gone through the excluded property, is family debt. So the Family Law Act defines family debt as it includes all financial obligations incurred by a spouse, A, during the period beginning when the relationship between the spouses begins and ending when the spouses separate. So this means debt incurred by one spouse before the relationship began is not the responsibility of the other spouse. So a lot of people will maybe have student loans coming into a relationship. That is not going to be the responsibility of their spouse. And then B, after the date of separation, if incurred for the purpose of maintaining family property. So as specified in Section A, debt incurred after separation by one spouse would not be the other spouse's responsibility unless the debt is used to maintain family property. So for example, if a party had to incur debt to pay property taxes or pay for necessary repairs on the family home, that would likely be considered family debt, even though it was incurred after the parties separated. And if you will recall, when we reviewed Section 81 of the Family Law Act at the very beginning, it states that each spouse is equally responsible for family debt, regardless of the respective use or contribution. So this means generally that during the relationship, any debt incurred by either spouse will be equally shared. So it doesn't matter if one party spent a lot more money each month on things like clothing or self-care, or just think maybe lavish vacations. The court is not going to go and do an accounting of who spent more, who charged more on the credit card during the relationship. And it's assumed that, you're together, you're one family unit, you're making decisions together. So debt should be, or is assumed to be, equally divided. So when people are in the process, maybe some of you are in the process of determining how to divide your assets, your debts, it's helpful for both parties to provide a detailed list of all of your assets and liabilities. And this process helps you determine what types of assets are family property, family debt. And once you do that list, or usually that's what I get my clients to do, the next task would be to determine the value of each of these assets and debts. So for example, if one party needs to transfer a portion of their savings or investments to the other, they would know how much to transfer because the numbers are there for them to work with. So the question is then, when we're looking at the law, what is the value of family property and family debt that we're supposed to use? So Section 87 of the Family Law Act provides how we're supposed to do this. So pursuant to Section 87B of the Family Law Act, the presumptive valuation date is the date of trial, or the date of an agreement dividing family property and debt. So I've encountered many people surprised that that property is not valued at the time of separation. So while you'll recall from Section 81, while your interest in family property is established as of the separation date, it's kind of like as of the separation date, you became a shareholder of all the family property and debt. So if you're not dividing property right at that moment, and you're maybe negotiating or and don't arrive at a settlement until months later, or you're not going to trial for a year and a half, um, it's kind of like now you've become a shareholder in that family property, and then therefore you are entitled to any increase in value of that property until trial or settlement. Next is the value of family property must be based on fair market value, and this is required by Section 87 as well. So fair market value has been defined in case law as the price at which a transaction would occur in an open and unrestricted market between informed and prudent parties acting at arm's length. So for real property, for example, typically what's required would be a appraisal um, to determine what the fair market value is. And so for a vehicle, you would also be looking at, okay, if you were to sell it in the open market, how much would you be able to sell it for? And then lastly, the court can depart from the presumptive valuation date, but that would require, that would be if it was significantly unfair. So remember I mentioned it's a high standard to meet, and we haven't gotten into the factors the Family Law Act considers when determining significant unfairness, but I'll do that shortly. But court decisions have said that departing from the presumptive valuation date is effectively unequal division. And so that's why there needs to be significant unfairness. Now on to unequal division. So Section 95(1) of the Family Law Act states that the Supreme Court may order an unequal division of family property or family debt, or both, if it would be significantly unfair to A, equally divide family property or family debt, or B, divide family property as required under Part 6, which is the pension division section. So at Section 95(2), the Act states, purpose of determining, for the purposes of determining whether equal division of family property or family debt would be significantly unfair. And the Supreme Court may consider one of the following. So you see that on the slide, and I'll just quickly go through them. The court may consider unequal division of family property, family debt, if equal division would be significantly unfair, considering the duration of the relationship, terms of any agreements between the spouses, a spouse's contribution to the career or career potential of the other spouse, whether family debt was incurred in the normal course of the relationship, the ability of each spouse to pay a share of family debt if the amount of family debt exceeds family property, whether a spouse after separation caused a significant increase or decrease in the value of family property or family debt beyond market trends, whether a spouse, other than acting in good faith, substantially reduced the value of family property or disposed of property that would have been family property. Next, tax liability that may be incurred by a spouse as a result of a transfer or sale of property or a result of an order. Then the extent, the financial means and earning capacity of a spouse have been affected by the circumstances of the relationship between the spouses, if the objective of spousal support have not been met when a determination respecting, oh sorry, we should have been with a determination respecting spousal support, and any other factor that may lead to significant unfairness. So usually, so you're seeing all these factors. Typically, a court would look at all of these factors and even more factors than what is listed here in the Act. As you can see, the very last point is any other factors that may lead to significant unfairness. So that that creates a situation in a lot of cases and situations where you're looking at many factors at once. Typically, the courts won't just look at one of these factors and focus on that one and make a decision on that one. That's that's usually not, or I'm not aware of any cases where a court has done that. Usually they're looking at the entire context, the entire situation of the relationship. So I've mostly just covered the basics of property and debt division, but also want to quickly touch on a few issues that may come up for you before you're able to reach an agreement or before you're able to get to trial, since the wait it is quite long. So there are some temporary orders related to property. So applications for orders can be made prior to a final agreement or a final order. And so they include interim distribution of property. So what this means is it's a advance payment to one or both parties of family property. And so Section 89 of the Family Law Act provides that the court can make an order for an interim distribution of family property to fund family dispute resolution. So you can't go and pursue this just because you need money for, I don't know, other endeavors, or just have more savings to give yourself more security. The interim distribution is only ordered if it is for the purpose of helping you resolve this family law issue. So either for retaining a mediator or arbitrator, or for legal fees for lawyers so you can get legal advice, or so they can represent you in court. So the point is to make assets available to the spouses to help them resolve the family matter, and what they want to do is to avoid a situation where one spouse does not have any funds for legal advice, and then thereby not being able to resolve this issue, or maybe resulting in very unfair result because maybe only one party has access to funds, the other one doesn't. And then another thing you could apply for in court is exclusive occupancy of a family residence. So this would be an order that only one spouse gets to live in the family residence to the exclusion of the other spouse. So pursuant to Section 90 of the Family Law Act, the applicant wanting exclusive occupancy must show that continued shared use of the home is a practical impossibility. So practical impossibility would be some, I guess the most obvious situation would be if there's family violence. It's not going to be considered a practical impossibility if your evidence is just that, oh, we don't really like each other. It's kind of awkward that we're living together. It needs to be something much more significant than that. And then the second factor the courts will look at is on a balance of convenience, the applicant should be the preferred occupant. So the court would consider various factors in the situation to determine who would be the preferred occupant. And they'd be looking at various factors like the interests of the children. So who the kids usually reside with. So if, the kids usually live with mom, or, and mom is the one, oh, sorry, and dad is the one wanting exclusive occupancy, probably won't go to dad because the courts will want the kids to be able to stay where they're most comfortable and most used to. And the courts will also look at other factors like the conduct of the parties' economic positions, availability of other accommodations to either spouse. So if you're applying for exclusive occupancy, but you have your family with a large house nearby and a basement suite available, but the other party doesn't have that, then that would be a factor that would support the other party having exclusive occupancy over you. And then the next two points or options for applications that could be made is possession or use of personal property stored at family residence. So there are situations where maybe one party is at the family residence, the other one moves out. There's things that they left behind, but that the party occupying the home won't return it to them. There are orders that you can seek to obtain personal property or possession of personal property. And then the last one on this section is the protection of property. So pursuant to Section 91 of the Family Law Act, it permits the Supreme Court to make an order restraining the other spouse from disposing of any property at issue. So if there's an order like this made, and the other party then after the order goes and transfer a bunch of their savings or investments somewhere else, they would be then in breach of a court order. So the Supreme Court related to protecting property, the Supreme Court can make orders for possession, delivery, or safekeeping of property. It can prohibit the other spouse from disposing of, transferring, converting, exchanging property which the applicant has an interest. It can make these types of orders to stop the other party from disposing of property. And then there are two other ways of protecting property. One is a certificate of pending litigation. So if you start a claim in the Supreme Court, a claim for a property and debt division, you file a notice of family claim or counterclaim if you are the respondent, you'll be able to file a certificate of pending litigation, which is like a charge against the title of the land, and it gives notice that there's a court action regarding that particular property. So this means that if the other spouse this means the other spouse cannot sell or refinance that property without the filing spouse agreeing to remove the CPL. And then the other one is if you couldn't or didn't want to start a court action yet, you could file a Land Spouse Protection Act entry. So this allows a spouse who is not on title of a property that they have been occupying to put a charge on title so the property cannot be sold or refinanced without the consent of the filing spouse. And you can do this without, like I said, without starting a court action, but the property must be located in BC. The parties must not be divorced at the time of this application. The entry only applies to property occupied by the spouses as their residence and which is owned by one or both of the spouses. And the application must be made within 1 year of moving out of the property by the applicant. So those are a few options for things that can be done related to property before a case is resolved. So I think we have a little bit of time. So I guess my last slide is just a summary of steps. Basically what I've discussed throughout today's presentation, just steps for you to look through and kind of help you run through all the different steps to consider while you decide and negotiate and discuss how to divide your property. Rachel, how are we doing for time? Maybe we want to leave more time for questions, and I won't go through each of these because it's basically a summary of what I said earlier.
Sure. Yeah, wrapping up about 5 minutes. So we'll add an additional 5 minutes to our question and answer period. So I'm just going to pull up our questions here. I think if we can have Anna join our conversation again. I think it might make the most sense to start from what Anna was discussing and then kind of work our way down to property again. So I just want a quick note to everybody that has submitted questions. We're going to try our best to answer as much as we can. Just a note again about legal advice and legal information. I know some of you are trying your best to get as much legal information as possible, but if it does line on legal advice, we won't be able to answer all of the questions. So the first one, okay. Is it true that marriages under 5 years do not include compensatory bases?
Not true. So you might have a situation, in fact, I'm sure I've read a case about this, where one spouse gives up their job and moves to BC in order to marry the other spouse. And then it doesn't work out. And now let's say the recipient moved here from another country, can't transfer their qualifications here, can't work without going through a period of retraining. So there's now a compensatory claim because they gave up their great career in the country they lived in to come and work here. It didn't work out after 2 years, and so there is a claim for compensatory support.
Okay, thank you. This one from Carmen, what if you are a senior citizen? I believe that's in terms of like if you are able to get spousal support.
It depends on whether there's a difference in incomes. So I have seen, for example, situations where the spouses separated. Actually, it was kind of sad. They were both like in their 80s, and they separated and they divided the pensions. And so they had equal income. And so there was no basis for support.
Okay. Let's see.
But I will say, let's say, you know, you're seniors and one senior has an income of $100,000 a year and the other one has an income of $20,000 a year. If there is entitlement, then yes, support will be payable.
Okay. Carmen, I do believe a couple of your questions will be answered when we discuss applications. I think that's week 5. So I think a couple of those will leave until that presentation. Okay, there's a question from Julia about judges going to, are judges in BC going to go by the revised user guide and
Yes.
acceptance listed there? Okay.
Yes.
Okay. In terms of the like less only 3 years of a relationship, I think this person was asking if it's not worth it for a recipient to ask for spousal support when the marriage is only 3 years.
Well, and that ties back to the example I just gave, right? It depends on the facts. So if it's only a 3-year marriage and both spouses worked and there is no economic disadvantage to a spouse, then no, there would be no reason to ask for support. But if they can establish economic disadvantage or advantage to the payor because of something the recipient did during that 3 years, then yes, there may be a claim for support.
Okay. What happens to support if one party dies during the family law case? It would both child and spouse support.
If there is an existing order or agreement, and it can be just an interim order, then the FLA has provisions that allow the court to make a continuing order for support against the payor's estate. But there are a lot of factors that you have to look at, and it may not be the same amount that was that would have been payable if the payor was still alive. And then if the recipient dies, then the support ends.
Okay. This one's a little bit of a long one, so I'm just going to read it out and we'll see if any of them, we may not be able to answer all of it. But does the term contractual encompass promises? What is the difference between the legal and social
I'm going to stop you right
promise?
there.
Yeah, that one's a little bit more legal
Yeah,
advice,
no.
right?
Contractual support is something in an agreement. Now, you know, so normally that would be a written agreement, like a contract. The courts in BC do recognize that that sometimes you can have oral contracts, like verbal contracts, but there has to be clear evidence that one spouse made offer, the other spouse accepted the offer, and there was an agreement, and any third party looking at this would clearly say, yes, there was a binding contract made verbally. And so whether the spouse made a promise to support the other through graduate school, there's a difference between, yeah, I'm promising I'm doing this because, we're married and I'm saying this, as opposed to, I am making a binding contract with you. I'm making a verbal contract with you, but it's a binding contract that I expect you to be able to legally enforce. Those are two different things. And so, again, that would be a tough issue for a judge to resolve. It would depend on whether there was outside evidence besides just the he said, she said between the spouses.
Thank you. Let's see. Did you have a chance to see any of the questions, Anna? Or
Yeah, so tax implications for paying child support.
yeah.
There are none, in the sense that you don't get a deduction. So, and that's why it's important to differentiate between the child and spousal support in your order or agreement, because otherwise it'll all be child support, it'll all be non-deductible. Now, one other tax implication that I didn't mention, if you are the recipient and you did have a lawyer for a period of time, and that lawyer helped you get an order or an agreement for support, or was pursuing it, some portion of those legal fees may be deductible from your income. And so that's something, like, if you had a lawyer for a period of time, that's something you should discuss with the lawyer, and they can provide you with a letter confirming, I charged client X this much money for legal fees related to spousal support. And then you submit that letter with your tax return to CRA, and then hopefully they allow your deduction.
Okay.
Um, this is a bit of an interesting question. How does the court see the fact that the recipient meant someone who helps her survive while she is waiting for spousal support?
Mhm.
Well, again, if that's, someone helped her out with a gift, or someone gave her a place to stay, that, if the entitlement, for example, is compensatory support, it doesn't matter, because it is, again, what happened during the relationship between the spouses that gives the recipient the entitlement or the right to the support. And the fact that someone helped along the way doesn't change that entitlement. And if it's non-compensatory, unless that someone who helped her survive is going to be permanently providing income to the recipient, again, it won't matter, because it's not, the obligation of family or friends to relieve the payor of their obligation to pay.
Okay. I think that we have about 10 minutes left, so I'm just trying to see if we should jump to some of the property. Oh, one came in at the bottom.
I'll answer the one about the self-employment, partner
Sure.
self-employed, likely underreports.
Sure.
That is like every business owner ever who's, deducts lots of expenses from their corporate income and says, oh, my income was only $14,000, but their business made, $150,000. One of the things that you do is that you look at, if the person is only saying, I only make $30,000, well, do they live a lifestyle that equates to them only making $30,000 a year? Or are they taking, lavish vacations and buying new cars, and that's not consistent with having that low income. And so what you'll want to do is you'll want to ask to see their credit card statements and their, bank account statements to see what kind of money is flowing through. So it's not just looking at the income tax return. But if you think that they are actually have more income, then you need to look at some of their other financial documents.
Okay, perfect. There was one that just came in at the bottom for spousal support. For the 65 rule for spousal support, does an application have to specifically state an indefinite period, or is it implied?
For rule of 65, it is indefinite. It's in the SAGs, so you don't have to ask for it.
Okay. Okay, I think we will jump to some of the property ones. Some of the other questions, like I said, I think will be answered by some of you in the following weeks. So just keep that in mind. So property for excluded, to Nancy. If a property is acquired more than a year after the separation date by one of the spouses, is it considered to be excluded property?
So I can give the general information because there's probably usually if this person was at my office, I would be asking a lot more other questions. But generally, if a property is acquired after separation and it's not from any assets, any family property. So for example, if a year after separation, someone got excluded property like inheritance, inheritance or a gift, and then purchase property, yeah, it would not be considered family property. However, situations where someone takes family property and then purchases new property after separation, that would be family property. So it depends on more facts than maybe the question has provided, but yeah, that would be my general answer.
The question about the Family Law Act versus the Divorce Act, are the
Right.
definitions the same regarding excluded property?
Right. So as I mentioned at the beginning, only the Family Law Act governs or provides for what happens with the division of property, division of debt, what is excluded property. So the law on property division is only in the FLA, because FLA is provincial legislation. The Divorce Act is federal legislation. And so pursuant to our Constitution, the federal government does not have the jurisdiction to make law on how property is divided. So that's why there's only definition of FLA because only the FLA sets out what is excluded property.
Okay. So this one's about a tax return. Okay, so
Seems a bit more legal advice to me, but what do you?
yeah, it's up to you. If that one we can also have Julia, you can email our info email address and we can see if we can have some questions answered at the panel if you have more information that's needed. See. What if one party used the property for all the time between separation and is devaluing the property? Is the other party going to be compensated by that?
Right. So that is one of the factors under Section 95(2) when we were talking about whether a court would unequally divide property. And so one of the factors in determining significant unfairness is whether a spouse, other than acting in good faith, substantially reduce the value of family property. So there are situations where if someone does that, that could be a factor that results in unequal division of that property.
Okay.
And so the compensation would be in the form possibly of unequal division.
I think you touched on this a little bit as well, the interim division of the property to fund the family law matter proceedings. I think that was also touched in our slides.
Yeah. I don't know, Julia, if you have further questions on that, or maybe she asked it before I got to it.
Before, yeah.
It
I'm not
was
sure.
before, yeah.
Oh, okay.
Yeah, perfect. Okay,
Well, I'm
good.
glad I'm glad I touched on that.
Okay, perfect. I think that's all the questions we have.
I'd like to just touch on the awareness or non-awareness of the other spouse's debt. I'm assuming this is debt that was accrued during the course of the relationship. It's if debt is incurred outside of the ordinary course of the relationship, then there may be an argument that it's not family debt. But so the example I used to use was that if your spouse racked up a lot of debt at the River Rock Casino that you didn't know about, then you could say that that was debt incurred outside of the ordinary course of the relationship and I shouldn't be responsible for it. But if you were driving him to the casino every day and you just didn't know how much he incurred, he could make an argument that, well, this was in the ordinary course of the relationship and then it was family debt. So that's the important part. Is it in the ordinary course of the relationship?
Perfect.
I think I see one says, what are some examples of evidence to prove excluded property that was blended into family property? So I think I mentioned earlier, bank statements, and it depends on what type of property we're looking at, right? So with things like bank accounts, investments, things like that, hopefully you haven't waited too long and you're able to get bank statements. And for things like real property, because what you're trying to prove is how much was it worth before you put it into family or before it became family property. Probably in most cases you had property and then you say got married or started living together, and then there's an increase in value. So how do you get evidence of that? So if it was real property, appraisers are actually able to do retro um, uh, basically historical appraisals. So they can look at comparables back at that time, even 10, 15 years ago, and they can provide an appraisal of the value of excluded property. And yeah, I don't know if, what do you think, Rachel? Am I getting at what they might be asking? I don't know if Anna has anything to add.
Yeah, I think that,
Evidence.
I think that's right.
yeah,
Yeah.
I think that summed up what they were looking for.
And then sometimes there are people who just don't have any access to any documents. So for example, maybe savings and things like that. So that makes it really difficult to prove. But I have seen some situations where some people it's just you go to trial and you're just providing your verbal evidence and you're going to be cross-examined and questioned on those on the facts that you're trying to forward. And so sometimes your last resort is just, well, at that point, this is how much I saved, and I know I took this and I put it into this other asset when we got married. So that's the last resort. But hopefully most people do try to keep some record on paper.
I think one last one, and then we will call it. What about stock investment increase? Do they need to be shared?
Post, they mean increase after separation during the relationship. So I'm not sure, but yes, increase in value if the stocks during the relationship,
During
thanks.
and after.
So during would be shared. After, depending on, so generally after as well, because like I said before, it's kind of like the other party, if it's your stocks investments in your name that you purchased before, the other party has an interest in it upon separation. So if that stock continues to increase, they already have an interest in that, so they're going to be able to share that. But there are situations where someone post-separation maybe is really is very, very good at maybe doing stocks, and there's a huge increase in value. There are situations where a court will consider, okay, was this increase in value completely based on this one person's extremely skilled expertise, and they're the sole reason why this this investment increased by such a significant amount? In those situations, there could be an argument for unequal division, but generally, yeah, they would be shared.
Okay,
I think,
perfect.
doesn't the legislation say outside of the ordinary, like, beyond market trends, an increase
Right,
or decrease
exactly.
beyond market trends?
Right.
Yes.
Perfect. Okay, I think we're going to, it's after 7:30, so I think with some of the question about uh, seeking orders, we're going to save something like that again in future weeks. So I think we're going to wrap it up here. And just a reminder for week 5, that's next week, Tuesday, October 10th. Again, it's going to be for 5:30 to 7:30, how to apply for fee waivers in the Supreme Court. If you have any further questions I didn't answer, again, you can email us at info@litigantschoolbc.com. Otherwise, oh yes, week 4. Thank you, Carmen. I am skipping ahead. It is week 4, BC Supreme Court. So thank you guys so much. Thank you to our speakers as well. And everybody have a good rest of your evening.
Thank you, Rachel.
Thanks.